Hi, I'm Brian with Hanning Law Limited, attorney for businesses and creatives. Today, I'm back with my series on trademark laws, and we're going to look at the types of applications that can be filed with the USPTO. And when we're looking at this, we're really looking at two different categories of application forms and two different types of applications based on usage. And we can mix and match those. So they're not exclusive one to the other. And when you apply through the USPTO, you're going to file through the Trademark Electronic Application System. Yes, you can do it by paper, but it's significantly more expensive. And why? You can, but it's just not the most effective way anymore. But this acronym of the Trademark Electronic Application System gives us the start of the application titles, T's Plus and T's Standard. And both applications, you can do them online, and they require more or less the same information, and they result in the same trademark certification upon registration. The difference is in what the T's Standard allows you to do, the T's Plus doesn't. So T's Plus requires you to complete the application up front, leave nothing blank, and to only use existent language in your description. We'll get to descriptions in another video, but it's things like we sell t-shirts, hats, socks, shirts, etc. We would have to use those particular phrases from their database instead of providing our own description. For most people, this isn't going to be an issue, and it does allow them to pay the lower price, which is $250 per international class, the subject of an entire video itself. But it doesn't make sense if you're doing something new. I'm using new here as a new type of product or something where there is no existent analog. And that's where we're really looking at the T's Standard application. Now this application is $350 per international class, and it allows you to write a description that doesn't exist. So for example, I had a client that was doing a product. That product was and is novel on the market. We wrote a new description for it, and there was nothing that we could really compare it to. It increased the fee, but it made sense for the client. Most applications can be filed at T's Plus, but like I mentioned, there are circumstances where we want more flexibility, more ability to describe what we're offering, especially if we're in a cutting edge industry like cryptocurrency or other patentable novel products. There may just not be a similar description, and so we might fall into this item. Like I said, we'll talk about descriptions and international classes soon. I believe they're the next episode, so good information on that is coming. But those are the two main applications that you can file, T's Plus and T's Standard. Within those applications, one of the main questions being asked is the basis for filing. Basis in this sense is I am filing a trademark that I am currently using or a trademark that I intend to use. And those are the phrases specifically used: in use, intent to use. And the difference primarily comes at the end. What I mean by that is when a trademark is in use, you are asked to provide a specimen. The specimen is photographic proof of your trademark in use. If you're a web store, you take a screenshot and show your trademark and the ability to purchase. Or if you're not there, maybe you're at a store and you take a picture of your tag in the store, that sort of thing. The trademark office has a guidebook for specimens that work. But basically what you're trying to do is create a specimen that identifies the trademark at point of sale. We're really trying to connect that consumer identification with the ability to purchase. Now, if you're intent to use, we don't file a specimen because you don't have the ability to do that. You don't have it in use. You can't take that photo. What you get instead of a full registration at the end of the process is a notice of allowance. That notice of allowance gives you 3 years, divided into 6-month chunks, to prove use. That proof of use is your specimen at the given time. When you come up on those 6-month periods, you're going to file a status update. You're either going to request an extension or you're going to prove use, provide that statement of use, and sometimes both if you're up against the clock. So that status update is $125 per class. So with the intent to use, you're potentially filing and having significant filing fees on top of your normal registration. I tend to advise people to try to be in use if possible, but I recognize that a lot of times, or in appropriate circumstances, it's just not reasonable, and you need to have the runway of the intent to use. And so, as I mentioned at the beginning, this is a mix and match situation. You can have a T's plus complete at the beginning intent to use application, and you can have a T's standard, maybe not fully filled out, flexible descriptions with a in-use application, or the other way. The important thing is to put together your application in a way that works for your situation and provides the best coverage. With that, I'll see you all next week with